The courtroom is tense again. Lawyers shuffle papers, witnesses wait, and everyone seems to know that what happens next could matter a lot. At the center of it all is a simple but powerful question. What really happened on election day when results couldn't be uploaded? An Amazon engineer has been called to testify, and now the cross-examination begins. Was the problem truly a technical glitch from Amazon's cloud systems? Or did the issue come from somewhere else entirely? The questioning begins quietly, almost calmly, but you can feel the tension underneath every sentence. The lawyer representing the Electoral Commission steps forward first. His goal seems simple: push the witness toward admitting that technical glitches can happen on Amazon's cloud systems. He starts with something basic. Glitches can appear after deployment, right? The witness answers carefully. Yes, glitches can occur in software systems after deployment. That much is true. But the conversation doesn't stop there. The lawyer immediately begins pointing to documents that had already been submitted to the court reports about the health status of AWS services across different regions. Then he asks about something called the Personal Health Dashboard. The witness nods. Yes, she's familiar with it, and she explains what it is in plain terms. The Personal Health Dashboard is a tool AWS customers use to monitor the performance of the services they rely on. If something goes wrong with the underlying infrastructure, customers can see it. It's essentially a window into the health of the system. The lawyer presses further. The Personal Health Dashboard itself isn't before the court, he suggests, but the witness pushes back gently. The information already submitted contains the same details about the system's health. At this point, the discussion moves into something a little more technical. AWS uses what's called a shared responsibility model. The witness confirms this immediately. Yes, that's correct. In simple terms, responsibility is split between two sides. Amazon manages the cloud infrastructure itself, the servers, the networking, the physical systems running in the background. The customer, on the other hand, is responsible for the applications they deploy on top of that infrastructure. The lawyer tries to narrow in on that distinction. If there were problems with an application deployed by a customer, he argues you would need a different type of report to identify it. But the witness isn't convinced by the direction of the argument. Not necessarily, she says, because applications still run on AWS services. If something significant were wrong at the infrastructure level, it would affect those applications too. And that's where the exchange becomes interesting. The lawyer seems to be steering the conversation toward one idea, that maybe the failure to upload election results could have been caused by a glitch somewhere inside Amazon's cloud. But the witness keeps returning to the same point. If there were a problem with AWS infrastructure itself, there would be visible indicators. The health reports would show it. Customers monitoring their services would see disruptions. Then another term enters the conversation: AWS CloudTrail. The lawyer asks whether the witness is familiar with it. Very familiar, she says. CloudTrail is a logging service. It records activity across an AWS account, creating a detailed trail of what happens inside the system. Every account has one. The lawyer points out that the CloudTrail logs for this particular case are not before the court, but the witness remains steady. She explains that the infrastructure health reports already provide insight into whether AWS services themselves experienced issues. And according to those reports, nothing unusual occurred on the day in question. And that leads to perhaps the most important statement in this early exchange. Glitches in software applications can happen, she acknowledges. That's not unheard of. But glitches affecting the primary function of a system, especially one running in a stable production environment available to the public, are highly unusual. You can almost feel the room pause for a moment when she says that, because suddenly the argument becomes much sharper. Yes, technical problems can exist in complex systems. Anyone who has worked with technology knows that. But the witness is drawing a very specific line. If AWS infrastructure had failed in a way that prevented the upload of election results, there would almost certainly be evidence of it. And according to the reports already presented, there wasn't. After spending several minutes circling around cloud infrastructure and technical reports, the tone in the courtroom begins to shift. The line of questioning slowly drifts away from the mechanics of AWS and into something a little more personal. You can almost sense the change in strategy. The lawyer, perhaps realizing that the technical route isn't yielding the admission he wants, starts bringing up examples from completely different industries. He asks the witness if she is aware of glitches that occurred in other systems. A banking issue involving the national currency platform. A telecom payment system that reportedly experienced failures. The witness listens, then answers plainly. She isn't aware of those incidents. Her focus, she explains, is AWS. And in that moment, the difference becomes clear. The lawyer is trying to build a broader narrative that glitches happen everywhere in all kinds of systems. Banking systems fail. Telecom platforms crash. Technology is messy. Therefore, perhaps the same thing could have happened here. But the witness refuses to follow that path. She keeps bringing the discussion back to what she actually knows. Amazon Web Services, cloud infrastructure, the reports she analyzed. Nothing more, nothing less. Then, the questioning takes another turn. The lawyer asks something that has nothing to do with servers' logs or cloud systems. Were you a candidate in the last election? The witness answers calmly. Yes. It's written in her witness statement already. Then comes the next question, sharper this time. You did not come to court on the authority of Amazon, correct? Again, the witness answers without hesitation. She is here as an expert witness, not on the mandate of Amazon. But the lawyer presses further, trying to frame the situation differently. So you are here as a political activist. The witness immediately rejects that description. No, that is incorrect. And you can almost hear the subtle tension in that exchange. Because what is happening now is no longer about technical systems. It's about credibility. The implication is clear. If the witness has political involvement, perhaps her testimony should be viewed with suspicion. But the witness stays consistent with her position. She isn't claiming to speak on behalf of Amazon as a company. She isn't presenting herself as an official representative. She's simply offering technical expertise based on publicly available AWS information and her professional background. Eventually, the questioning slows down. The lawyer pauses, then signals that he has no further questions. And watching the moment unfold, you can't help but notice how the conversation evolved. What began as a detailed examination of cloud infrastructure gradually shifted into an attempt to question the witness herself, her affiliations, her role, her motivations. But through it all, the witness kept returning to the same simple point. She was there to speak about AWS systems, nothing more. Just when it seems like the questioning might return to the technical issues, the direction changes again. This time, the lawyer shifts his attention to something else entirely, the witness's employment verification letter from Amazon. He asks the witness to look at the letter that had been submitted to the court. Then he points out something he believes is suspicious. The document, he says, has no author's name on it. Instead, the letter lists something called the Employee Resource Center. The lawyer pauses and then suggests something that makes a few people in the courtroom raise their eyebrows. Is the Employee Resource Center a person? The witness answers calmly. No, it's not a person. It's a department within Amazon that handles employment verification. That explanation sounds straightforward enough. Large companies often use centralized departments to issue official confirmations like this. But the lawyer isn't ready to move on. He notices something else. The letter, he says, is not signed. Again, the witness responds. It is not signed by the Employee Resource Center, she explains, but there is a signature attached to the document. And she adds that this type of verification letter is the standard format Amazon provides to employees when they need proof of employment. But the questioning keeps circling. The lawyer then asks another question that seems to push the same idea that perhaps the witness cannot prove she actually works for Amazon. Where is your ID card? At this point, the exchange starts to feel a little strange. The witness answers simply, Amazon Web Services does not issue ID cards. If you've ever worked in large organizations, that answer might not sound unusual at all. Some companies rely on digital verification or internal systems rather than physical ID cards. But the lawyer presses further. Was there an appointment letter given to you when you joined? The witness replies that the employment verification letter already confirms her appointment and position. And listening to the back and forth, you can sense a pattern developing. Instead of challenging the technical analysis the witness provided earlier, the lawyer seems to be testing the edges of her credentials looking for any small inconsistency that could weaken her credibility. But each time a question comes up, the witness responds in a calm, straightforward way. The Employee Resource Center is a department. The verification letter follows Amazon's standard format. AWS does not issue ID cards. Nothing dramatic. No raised voices. Just quiet answers that gradually close off each line of attack. Eventually, even the lawyer seems to realize that this particular path isn't going anywhere. So after several minutes of probing the document from different angles, he finally moves on to something else. After the detour into employment letters and credentials, the questioning slowly finds its way back to the subject that started it all: technical failure. But this time, the lawyer approaches it from a different angle. Instead of asking about AWS reports or infrastructure logs, he reaches into the witness's own past. He reminds the court that this is not her first time appearing in legal proceedings. Then he begins asking about a previous case she filed. The witness confirms that she had once taken legal action after her name was not included on a list of candidates. According to her explanation, several attempts had been made to upload information to the electoral system, but those attempts failed. The lawyer seizes on that moment. So there was a network problem at the time, he suggests. The witness acknowledges that there were difficulties during the process, but the lawyer pushes the point further. Isn't a network failure simply another form of glitch? It sounds like a clever way to reframe the discussion. If a network issue could prevent something from being uploaded in the past, then perhaps something similar could explain the election result upload problems. But the witness doesn't accept the comparison. She disagrees with the suggestion outright. Network failure, she explains, can happen on the side of the person attempting the upload. It doesn't necessarily mean the platform itself has failed. In other words, a connection problem on a user's end is very different from a system-wide infrastructure glitch. The lawyer then points to something else from her earlier affidavit. In that document, she had stated that a particular website had crashed at the time. Yes, the witness confirms that was her statement. But again, the conversation doesn't stay there for long. The lawyer pivots to something much broader: historical outages within Amazon Web Services. He brings up an incident from February 28, 2017, when the AWS S3 storage service experienced a significant disruption. The witness says she is aware of that event. Then another number appears in the questioning. Reports indicating that AWS had experienced more than 20 outages during that same year. Again, the witness acknowledges that she is aware of such records, but she also explains why those historical events were mentioned in her own report. They were included as part of the health status reports she submitted to the court. And that explanation reveals something important. The lawyer seems to be drawing a simple conclusion: if AWS has had outages before, then it could have had one on election day as well. But the witness is clearly separating those ideas. Yes, outages have occurred in the past. Like any massive technology platform used around the world, AWS has experienced disruptions at different times. But past outages do not automatically prove that a new outage occurred on a completely different date, in a completely different context. And that is the core of her response. The issue being examined in the courtroom is very specific. It concerns the events of February 25, 2023, not 2017, not some other year, that particular day. And according to the infrastructure health reports already submitted, there was no indication that AWS systems experienced the kind of failure that would prevent the upload of election results. Listening to the exchange, you start to notice the pattern again. The lawyer keeps widening the lens, bringing up other incidents, other systems, other possibilities. But the witness keeps narrowing it back down to the same point. What actually happened on that specific day? And on that question, her answer doesn't change. Just when it feels like the questioning might finally slow down, another lawyer rises to take his turn. A different voice, a slightly different strategy, but the focus remains on the same witness. He begins with a direct question. Did you conduct any investigation into the actual application used during the election? The witness answers carefully. She explains that she carried out what she describes as a preliminary investigation into the IRV platform. Then she adds something important: the system in question is not an application in the way the lawyer seems to be describing it. The lawyer moves quickly to the next point. If there was a glitch, he asks how many votes were affected, but the witness doesn't take that bait. She calmly reminds the court that she is not there as an election expert. Her report, she explains, is about something very specific. According to the AWS infrastructure data she reviewed, there were no glitches within the AWS systems themselves. That distinction becomes the center of the next round of questions. The lawyer asks whether she is aware that companies using AWS typically operate under agreements, things like non-disclosure agreements. The witness acknowledges that she is aware of service-level agreements between AWS and its customers, but she does not confirm the existence of a specific NDA between AWS and the Electoral Commission. Then comes another question. Does she have a copy of the service-level agreement between the Commission and AWS? Her answer is straightforward. The service-level agreement she referenced applies generally to AWS customers. It is a standard agreement, and she had already attached a link to it in her witness statement. She makes it clear again she is speaking about the general structure of AWS services, not about the private operational details of any specific client. But the lawyer keeps probing. Within that agreement, he asks, are there confidentiality clauses covering the operation of the application? The witness pauses before answering. She says she cannot state that categorically. The lawyer then turns to another angle, entirely password protocols. Surely, he suggests, there must be passwords controlling who can access or modify the system. The witness responds almost immediately. She does not work for the Electoral Commission, she says, and she has no knowledge of their internal password protocols. That's simply outside her scope. So the lawyer focuses on the report she prepared. When you accessed the information used in your report, he asks, did you need any password? No, she says. That answer sparks the next question. So the information you relied on is publicly accessible? Yes. And the witness clarifies once again that everything included in her statement is drawn from publicly available AWS infrastructure data. The lawyer then asks something that seems almost like a final test. If the information is public, could she modify it herself? The witness answers firmly. No, she cannot modify it. The data is public to view, but it cannot be altered by her. Finally, the lawyer circles back to a point raised earlier. You are not representing Amazon in this case. Correct? The witness repeats what she has already made clear. She is not here as a representative of Amazon. She is appearing as an expert witness. And as the exchange settles, you can see the shape of this round of questioning. The lawyer tries to establish limits on what the witness investigated, limits on what she can access, limits on what she can claim. But the witness keeps returning to the same foundation. Her testimony is based on publicly available AWS infrastructure information. Nothing hidden, nothing private, just the data that anyone monitoring the health of the cloud systems could see. After the witness steps down and the technical arguments begin to fade from the spotlight, the atmosphere in the courtroom shifts again. Now the focus moves away from cloud infrastructure and into something more procedural, documents that the petitioners say the Electoral Commission has been avoiding. The lead counsel for the petitioners rises and addresses the court. He explains that after several attempts, they have finally managed to serve a subpoena on the commission. What they want to know now is simple. Has the commission brought the documents that were requested? A representative of the commission stands up to respond. She introduces herself and explains that she is appearing on behalf of the chairman. Her role, she says, is connected to the department that handles certification complaints and legal documentation. She tells the court that she came in response to a subpoena dated May 30th. But then comes the complication. According to her explanation, the documents requested under another subpoena dated June 13th will actually be presented by someone else. The exchange immediately becomes tense. The petitioner's lawyer pushes back, reminding the court that the commission has been avoiding these subpoenas for weeks. Since May, he says there have been repeated attempts to obtain the requested documents. The representative replies that they were only served properly the previous day. That claim sparks a reaction in the courtroom. Murmurs ripple through the room as people express disbelief. Still, the discussion continues. The lawyer presses the issue directly. When exactly will the documents be produced? The representative explains that the documents are not immediately available. They are located in different states across the country, she says, and gathering them will require logistics. The answer does not sit well with the petitioner's team. The lawyer sounds visibly frustrated now. What does "as soon as possible" even mean, he asks. After weeks of delays, they are now being told the documents are scattered and need to be transported. He turns toward the judge, emphasizing that the commission has been avoiding compliance since the petitions were filed. At that point, the presiding judge steps in. She asks the representative a straightforward question. When will the documents be available? The representative repeats that logistics are required. She also adds another condition payment for the process of producing the documents. That statement triggers another round of objections. The petitioner's lawyer quickly responds that payments have already been made for earlier requests, and if more payment is required, he insists they are ready to pay immediately. But what he finds unacceptable is the suggestion that the delay is caused by unpaid fees. He argues that the commission cannot ignore a subpoena for weeks and then suddenly claim the documents cannot be produced because service happened only yesterday. The judge once again tries to restore order. She points out that the representative is saying the documents are not currently with her. Meanwhile, the frustration among the petitioner's lawyers becomes harder to hide. Their murmurs grow louder until the judge addresses them directly, asking them to calm down and maintain proper courtroom conduct. Still, the underlying issue remains unresolved. If the commission fails to produce the documents, the petitioners argue that would amount to disobeying a court order. Eventually, some documents connected to the June 13th subpoena are presented, but not all of them. And with that partial compliance hanging in the air, the court decides to adjourn the proceedings, pushing the matter forward to the next day. And after all the questions, arguments, and tense exchanges, the central question still sits right at the heart of the case. Was there truly a technical glitch that stopped the election results from being uploaded? Or was something else responsible? The courtroom will keep digging for that answer as the proceedings continue. If you found this breakdown helpful, feel free to support the video and stay with the story as the next day of hearings unfolds.